If your home is paid off and you are over 60, your local council treats you differently from every other homeowner in your area, and the difference is not in your favor. The moment you or your spouse needs long-term care, the council will assess everything you own, and your home, the one you spend 30 or 40 years paying off, is the single biggest asset they are looking at. Right now, in England, the average cost of a residential care home is £1,298 per week. That is £67,496 a year. A nursing home is even higher, at £1,535 per week, which works out to just under £80,000 a year. And if your loved one needs dementia care, you're looking at closer to £1,564 per week. The average stay in a care home is just over 2 years. So you're looking at a total bill somewhere between £135,000 and £160,000 for a standard stay, and far more if dementia is involved. That is more than most people have in savings, which is exactly why the council comes looking at your property. Here is how the system works, and here is what you can do about it before it is too late. I am going to walk you through 5 things every homeowner over 60 needs to understand, and 3 moves you can make right now to protect your home. Stay until the end, because the third move is the one that almost nobody knows about, and it is the most powerful of all. The first thing you need to understand is how the council decides who pays. When someone needs care, the local authority carries out a financial assessment, sometimes called a means test, and it looks at absolutely everything: your savings, your investments, your pensions, any property you own. In England, there are 2 capital thresholds that determine what happens. The upper limit is £23,250. If your total assets, including the value of your home, are above that number, you are what they call a self-funder, and you pay for everything yourself. The council does not contribute a single penny. The lower limit is £14,250. Below that, the council covers most of your care, and you only contribute from your income. Between the 2 limits, you get partial help, with the council charging you £1 per week for every £250 of capital you have above the lower limit. Now, here is the part that catches families completely off guard. If you move into a care home permanently and nobody else is living in your property, the value of your home is counted as part of your capital. A 3-bedroom house worth £300,000 pushes you well above that £23,250 threshold, and you become a self-funder overnight. Your home, the one you thought was your family's security, just became the council's funding source for your care. The second thing you need to understand is when your home is protected and when it is not. There are specific circumstances where the council must disregard the value of your home and cannot force a sale. Your home is disregarded if your spouse or civil partner still lives there. It is disregarded if a relative who is over 60 still lives there. It is disregarded if a relative who is disabled or incapacitated still lives there. And it is disregarded if a dependent child under 18 still lives there. So if your husband or wife is still in the house, the council cannot count the property and cannot force a sale no matter how much it is worth. That protection lasts for as long as they remain living there. There is also a 12-week property disregard that applies to everyone. For the first 12 weeks after you move into a care home permanently, your property is not counted. This gives families a breathing period to make decisions. But after those 12 weeks, if none of the permanent disregard conditions apply, your home goes straight into the means test and the clock starts ticking. The third thing you need to understand is the deferred payment agreement and why it is not the safety net people think it is. If your home is being counted and you do not want to sell it immediately, the council must offer you something called a deferred payment agreement, sometimes shortened to DPA. This sounds helpful because it means you do not have to sell your home right away. The council effectively lends you the money to cover your care fees and puts a legal charge against your property. The debt, including interest, is repaid when the property is eventually sold or when you die. But here is what nobody explains properly. The interest rate on a deferred payment agreement is not zero. For the first half of 2026, the maximum rate is 4.75%. On a care bill of £150,000 over 3 years, that interest alone adds thousands of pounds to the total. There are also administration fees, typically between £400 and £600, and the council will usually only lend you up to 70 or 80% of your home's value, meaning you still might need to find the rest from somewhere else. A deferred payment agreement does not protect your home. It delays the sale while the debt grows with interest. Your family still loses the house in the end. The council just waits until you are gone before they collect. The fourth thing you need to understand is the deprivation of assets rule and why giving your house to your children does not work the way most people think it does. A lot of people assume they can simply transfer ownership of their home to their children or grandchildren, and then when they need care, the council cannot touch it because they no longer own it. This is one of the most dangerous assumptions in retirement planning, and it is wrong. If the council believes you deliberately gave away assets to avoid paying for care, they can treat you as though you still own them. This is called notional capital. It does not matter that the house is in your daughter's name on the title deeds. If the council decides the transfer was done with the intention of avoiding care fees, they will assess you as if you still own the property and calculate your contribution accordingly. And here is what makes this even more serious. Unlike inheritance tax, where there is a 7-year rule for gifts, there is no time limit on the deprivation of assets rule for care fees. The council can look back as far as they want. There is no safe number of years after which you are in the clear. What matters is not when you made the transfer, but why you made it. If at the time of the transfer you could have reasonably expected that you might need care in the future, the council can challenge it. And it gets worse. If the council decides deprivation has occurred, they can pursue the person you gave the asset to. Your daughter, your son, whoever received the property, can be held liable for the difference between what the council charged you and what they would have charged you if you still owned the asset. So the very person you are trying to protect could end up receiving a bill from the council for tens of thousands of pounds. Now, the fifth thing, and this is where it starts to work in your favor. There are legitimate legal steps you can take to protect your home and your family's inheritance, but you have to act early. Move number 1 is changing how you own your property from joint tenants to tenants in common. Most married couples in the UK own their home as joint tenants, which means when one of them dies, the property automatically passes in full to the surviving spouse. That sounds sensible, but it creates a problem. When the surviving spouse later needs care, the council assesses the full value of the property because they own 100% of it. If instead you change the ownership to tenants in common, each person owns a defined share, typically 50%. When one spouse dies, their 50% can be left in a trust or directly to the children through their will. The surviving spouse continues to live in the home on the strength of their own 50%, but only their share is assessed for care fees. The other half has already been passed on and is outside of the means test. This is a simple legal change that a solicitor can arrange for a few £100s. It does not trigger any tax consequences, and it does not affect your ability to live in or sell the property while you are both alive. But it needs to be done while you are both healthy and well, before any care is needed. If you do it after one of you has been diagnosed with a condition that might lead to care, the council could argue deprivation. Move number 2 is setting up a lasting power of attorney. A lasting power of attorney, or LPA, is a legal document that allows someone you trust to make financial and health decisions on your behalf if you lose the mental capacity to make them yourself. There are 2 types. One covers property and financial affairs, and the other covers health and welfare. If you do not have an LPA in place and you lose capacity, the only way your family can manage your finances is by applying to the Court of Protection. That process can take months, costs more money, and gives you far less control over who makes the decisions. Setting up both types of LPA while you are still well means you choose who manages your affairs. You choose how your property is handled, and you keep your family out of an expensive and stressful court process. It costs £82 per LPA to register with the Office of the Public Guardian. Or you can apply for a reduction or exemption if you are on certain benefits. A solicitor can help you draft one for between £300 and £500, or you can do it yourself online. Move number 3 is the one that most people have never heard of, and it is the most powerful protection available. It is called a property trust, sometimes called a life interest trust, or a protective property trust, and it works by placing your share of the property inside a trust when the first spouse dies. Here is how it works. You and your spouse own the home as tenants in common, 50-50. You each write a will that says, when I die, my 50% share of the property goes into a trust for the benefit of our children. But my spouse has the right to continue living in the home for the rest of their life. When the first spouse dies, their half goes into the trust. The surviving spouse carries on living in the home as normal, paying the bills, maintaining the property, doing everything they always did. But they do not own that 50%. The trust owns it. And because they do not own it, that 50% is not part of their capital when the council does a means test. If the surviving spouse later needs care, the council can only assess the 50% that they personally own, not the 50% sitting in the trust. On a property worth £400,000, that means only £200,000 is assessable instead of the full £400,000. And the £200,000 in the trust passes directly to your children when both parents have died, completely outside the means test and completely outside any care fee claim. This is not a loophole. This is not aggressive tax planning. This is a legitimate, widely recognized estate planning tool that any competent solicitor can set up as part of a standard pair of mirror wills. The cost for the wills, the tenancy in common change, and the trust structure is typically between £500 and £1,000. But, and this is the part I need you to hear clearly, it only works if you do it before you need care. If you wait until one of you is already in a care home or already showing signs of needing care, the council can challenge the arrangement as deprivation of assets. The time to act is when you are both healthy, both clear-headed, and both living at home. That is when the protection is strongest and the cost is lowest. Let me pull all of this together. If your home is paid off and you are over 60, you are sitting on the single biggest asset the council will come looking for when care is needed. The thresholds have not changed since 2010. £23,250 has been the upper limit for 16 years, while care costs have more than doubled. The system is designed so that anyone with a paid-off home is almost certainly going to be a self-funder. But you do not have to be caught off guard. Change your ownership to tenants in common. Set up both types of lasting power of attorney. Put a protective property trust in your wills. Do all three while you are healthy, and do all three with a solicitor who understands care fee planning. The total cost for everything is typically under £1,000. The value of the home you are protecting could be $300,000, $400,000, $500,000 or more. That is the single best return on investment in your entire retirement. I will put all the details, the links, and the steps in the description below. Do one thing for me. Send this video to one person you know who is over 60 and owns their home. A parent, a sibling, a friend, a neighbor. The odds are very good that they have no idea how the council treats a paid-off home when care is needed, and one share from you could save their family £100,000 or more. That is what this channel is here to do. I will see you in the next one.